All right, welcome back. For those of you that are back, for those that are you watching later, I hope you had a nice break from the last class. Today we are lucky enough to have a guest speaker with us for this class. Miss Lisa is going to talk to us from Abstracts and Titles, and she's going to spend the next hour or so. The magic that happens in a title company after you get a contract, right? And after you guys negotiate it and the buyer takes the earnest money and drops it off at the title company and the seller sends the contract over to the title company. She's going to talk to you about the magic that happens in the title company so that 6 weeks later you can show up and all is well. So, Lisa, thank you for joining us today. We greatly appreciate you, and have at it.
All right. Well, I want to say thank you for having me, of course. I'm very happy to talk about title insurance. My name is Lisa Engelke. I am with Abstracts and Titles, as was previously discussed here. Um, I've been with Abstracts since 2001, part-time until 2008, and I've been full-time since then. Basically, like he started off, once we receive the contract, that is sort of our starting point. This is when we jump in, and sometimes there's problems initially off the bat. Sometimes you don't know there's problems until we finish our title commitment. But we receive a signed contract, earnest money, what have you. We open an order and we start a title search. The end result of that search is what we call a title commitment or a commitment for insurance. It's a preliminary report, and it's commonly addressed as a condition of title. That's not really the true function of it. What a commitment for title insurance is a title company's commitment to issue title insurance. It's pretty self-explanatory. So I have an example here. It's of course very Disney themed, so I'll warn you in advance here. But I'm just going to go over an example of a condition of title just to see what you would commonly find when we produce the title commitment. So I am going to, all right, let me go back to the top here. So this is just an example that I've composed. This is the same commitment that I used the last time I spoke here. So the dates are the same, all the information is the same. I'm just going to kind of give a brief summary again here. The title commitment typically has 3 pages to give you the fine print of a commitment. I didn't include it in this one. I just wanted to get straight to the nuts and bolts of this. The first important or first page that would stand out is the Schedule A for the commitment for title insurance. And I'm going to go over certain areas of this commitment. We call this Schedule A. This is the first schedule. There's usually Schedule A and Schedule B included with the title commitment. Schedule A has all the proposed information. So we have 2 policies that need to be issued because as a title insurance company, our end goal is to issue a policy. And the 2A would be the proposed policy to the new buyer. And in this case, our new buyer is Mickey Mouse and Minnie Mouse. The proposed policy amount always reflects the sales price at $250,000. 2B is a loan policy. This is the policy that's issued to the bank to protect their investment. They want to make sure there's no major defects with the property, make sure that they're in first position on their loan. So they also are issued a policy when they're involved. And in this particular case on 2B, we have Walt Disney Bank Inc., and their proposed policy amount is $200,000, which usually reflects the loan amount. Back up on item 1 here, you have the commitment date. Basically what this is saying is that this property has been searched since January 11th, 2021 and prior. This does not reflect obviously anything of a future date because we don't know if anything has been recorded, anything else has changed since we've issued this report. Again, I just want to stress that a commitment that we've recently issued would reflect a more current date. Since this is an example that I'm using that's a little bit older, it still says January 11th. So if you received a commitment today, it most likely would have a date from March or, worst case scenario, the end of February. So scrolling down here, excuse me, to item 4. This is where you have the seller's information. This is a very beneficial part of the commitment if you have any concerns about the seller that signed your original contract. Did you have, heirs involved? Did you have all the heirs signed? Did you have a husband and wife, but only, one person signed? Title to the fee simple estate or interest in the land is as the commitment date vested in, and then it lists the individual, trust, LLC, whatever the case may be. In this case, we have Daisy Duck. So item 5 describes the land that we're insuring, and usually this is attached at the end, so we will go over that later. So that is in a brief summary, that is Schedule A. It has the proposed policies that we intend to issue reflecting buyer and bank, sales price and loan amount, and then it shows who your owner is. So we're going to scroll down to Schedule B, Part 1. Schedule B, Part 1 is our requirements section. So basically, when we're saying in Schedule A that we intend to issue a title insurance product, the catch to that is that we will, as long as all the requirements are met within Schedule B, Part 1. So title companies title companies have standard requirements that are listed on, and every title company has different standards. So you have 1 through 10 on our commitment are all standard exceptions. They and just to pick out a few of them, sometimes they change, sometimes we remove them. This particular time of, we have something along the lines of that all documents have to be executed. So basically saying anything that's required to transfer title, we're not going to issue a policy until all the required documents are executed. That's a standard that you have to have identification, so that you have to have, that we can verify and notarize any documents to verify you are who you say you are. That is a standard requirement. That you have to have certain types of funds, whether money order, cashier's check, wire, depending on the situation. We say that in the requirements section that you have to have certified funds to close. So they're all just standard general requirements. I believe we have added an 11th one since I've done this presentation, but they're all just, general standard exceptions. When we get to number 11 is when we start to get specific to our file. So you'll notice usually the first one that's specific is the request for the warranty deed. So in this particular situation, we have the warranty deed from Daisy Duck, surviving joint tenant of Donald Duck, vesting fee simple title in Mickey Mouse and Minnie Mouse. And if you'll notice, in my example, I unfortunately made Donald Duck a deceased party here. So the summary is that Daisy and Donald own this property together, but Donald Duck passed away. And since they owned it in joint tenancy, Daisy Duck is the surviving owner. So in order for us to issue an owner's policy to Mickey and Minnie, they have to have a deed signed by Daisy conveying the property to both of them. Item number 12 works in the same way. For the loan policy, in order for us to issue the loan policy to the bank, Mickey and Minnie have to also execute a mortgage. So basically, you can't have the owner's policy without the warranty deed. You can't have the loan policy without the mortgage executed. You also have on item 13 a release of mortgage. Basically, Daisy and Donald at some point in time and had a mortgage on this property that has not been paid off in full. So in order for us to issue free and clear title to Mickey and Minnie, this is an issue that has to be cleared up before we can go to policy. And that's usually something that's taken care of at closing. Item 14 refers to homeowners association dues. Homeowners association dues are a lienable item. That's why they're a huge concern for title insurance companies. If Daisy hadn't paid her homeowner association dues for the last 6 years, there's most likely going to be a lien on the property. That affects the mortgage company's priority on the property. It will affect the ownership for Mickey and Minnie. So we want to make sure that those are all current, all taken care of, so that they don't cause any conflict for the new owner and the new lender. Number 15 is probably one of our most common requirements that's listed on the commitment, and it's talking about a lien that we found of record in Madison County. So this one is talking about from February 2018 against Daisy Duck, 5 Cherry Tree Lane, Ursula, Illinois, in the amount of $9.99 plus penalties and interest. So if we go to our first page, you'll know that this is not the address that's reflected on your contract. So immediately you're thinking, this isn't my person. That could very well be the case. But we've had situations where, maybe this is a rental property for Daisy. Maybe she doesn't live in this, and maybe she does truly live in 5 Cherry Tree Lane. What we need to do is we need to have a verification form completed that truly verifies that she has never lived or owned the property at 5 Cherry Tree Lane. If we can eliminate that this is not her judgment, then we can take it off the title commitment or resolve it before or at closing. Liens are an issue, especially when they're against the seller. They attach to property. So you don't want this to become a problem for the new buyer, and you also don't want anything that the buyer has to be attached to the new property. That could be an issue for the lender, having priority of their loan. So that in a nutshell is Schedule B, Part 1, requirements. And again, the requirements section is just anything that we would need to close this properly and to issue policy to the parties involved. Schedule B, Part 2 is the exceptions. So where the requirements say this is what we need, the exceptions say this is what is of record, or this is what we will not cover in any claim on our insurance policy. Again, you have standard ones involved in this. Anything basically that's unrecorded. Some people have agreements between one or two parties, but they've never recorded it. A title company can't be held responsible for anything that isn't recorded and isn't public record. You have taxes that are an exception from coverage, and we'll go over this in more detail over our ALTA statement, but we always list the details of real estate taxes. If you're not familiar, or you're just getting used to dealing with Madison County taxes, we're always a year behind. So 2019 is the most recent bill that's been paid. 2020 will not be released until this summer, and 2021 will not be considered until 2022. So we're always a year behind. In this particular situation, I wanted to have a tax bill to pay on your ALTA statement, so I did make sure the 2019 general taxes were not paid. And then I did note that there was a exemption of $6,000. Anything that's a discount, if you have a senior citizen freeze, if they're a disabled vet, any reason that they would have additional discounts, there could be home improvements, etc., that would be listed in this section here. If it's not listed, it's usually not something that they're being awarded towards their final assessment. Permanent parcel number, I just left it 0. This is the format of a Madison County parcel, though. This is the unique identification number for Madison County property. Anything that can be found for tax bills can be found using this specific ID number. So that's always listed within the exception for real estate taxes. Again, 5, 6, and 7 are standard ones. We don't get into the specifics until we get to around 10 or 11, the same as the requirements section. And just to summarize, most of these exceptions, are necessary things. The examples that I had included in this one was a couple of easements, one's for power, one's for sewer. Those are things that you have to have. So basically, these companies have the right to have this strip of land, or whatever the case may be, to get a sewer line, to get a power line to the house. It's an essential easement for the property to have basic utilities. You have building lines, utilities, ordinance that I put on this example saying it's annexed into a different city. There's a road maintenance agreement, which can usually indicate that there's a private road that more than one party takes care of, whether it be, shoveling the snow, putting new rock down, that kind of thing. You have a fence installation hold harmless agreement. That is something that basically says a fence has been installed over an existing utility or existing easement. Usually it's to the local municipality. And it basically just says if the fence has to be removed, if the city or the municipality has to have access to this easement, they'll have to remove the fence to get to it, and the owner will have to hold them harmless. Some of these things are never touched. They're just on there just in case, worst case scenario occurs. The last one I put on here was the covenants, conditions, and restrictions. That is a standard exception with any subdivision. Basically, usually any subdivision has covenants and restrictions, and it's a common request for realtors to ask us for a copy of their particular subdivision, because you have certain things that you can and can't do that are listed in covenants and restrictions. The funniest one I've probably seen is the fact that you can't have livestock on your property. They do specify, like, you can't have, cows, you can't have chicken on your property. It's just the range of things that they can list in there is very rare and very odd. But certain subdivisions say you have to have a specific type of mailbox, that, if you don't have a subdivision or a sidewalk in front of your particular lot, that you would be responsible for installing it. Covenants and restrictions have just a broad range of issues that they cover. So it's always something that is accepted in our policy. And of course, copies are always available, if needed. So this summarizes the exceptions. The last two numbers, 19 and 20, refer to the mortgage company's loan policy, basically saying what additional coverage we're going to provide them in their loan policy. We always have a chain of title if a lender is involved. A chain of title basically expresses how the property was acquired by the current owner and addresses any additional conveyances in the last 2 years. So this one, we addressed that Donald and Daisy obtained ownership in June of 1989, and they owned it in joint tenancy. And upon Donald's death in March of 2020, it became, Daisy's property solely as the surviving joint tenant. And then finally, Schedule C is the legal of the property. If you want to make sure on your contract that you listed the correct lot number, the correct subdivision, maybe it's a phase 1, phase 2, if you want the specifics, this is where you can find your legal description. And this one, lot 55, 100-acre wood subdivision, commonly known as 101 Dalmatian Drive in Orlando, Illinois. So that's the title commitment in a nutshell. I have an ALTA statement to go over next, but I can stop and address any questions if anybody wants me to go back over anything or explain further on something, or we can, if you want to save your question till the end, that's fine too. So if I don't have any, I'm gonna move on to the ALTA statement.
Hey, Lisa.
Yeah.
When should we expect the title commitment? How long does it take typically to get a title commitment? I'm going to ask you questions because they're new, so they don't really know what to ask you. God bless them.
It depends on how busy we are. Right now, it's very bad. We're just swamped. I mean, the industry is doing extremely well right now. So right now, the key to that is, do we or do we not have a prior file? That's the key to that question.
And how do we do that with our sellers then?
Well, if you know the title company that you're ordering it from, I would give them a call first and say, do you have a prior for, example, 101 Dalmatian Drive? And, the title company will search their index and they'll be like, well, I don't see one. Like, our records are computerized 96 on. So we could tell you if we've searched it since 1996 till, present day. We've been open since 65. So we could address paper records that take a little bit more research, but we could find out for you if we've searched this property. If we have a prior file, it can be done in a handful of weeks. So usually within 2 to 3 weeks. If we do not, it's usually closer to a month before we can get a title commitment, because we have to do a full search. So if we do not, or if you don't even want to call the title company, a blanket question you could ask any, listing agreement you have signed, any contract you have signed to the seller is, do you have your prior owner's policy? And your owner's policy is always sent to you after, usually 30 to 60 days after closing. That is your, insurance product. The whole purpose of this commitment. Once the closing is done, the title company issues the owner's policy to you and sends it in the mail. And so if you have that prior and provide that to us, that's the same as if we had done the search, if we had a prior file on it, and that does expedite the process. So, to summarize that really quickly here, if your seller has a current owner's policy, we can use that as a prior. Or if your title company that you're using has searched this property and insured it previously, that expedites your search. So I would say 2 to 3 weeks with the prior, whether it's from us or another title company, and 4 weeks for us if we do not have a prior.
So also you could, if they don't have the title commitment, they could also look back at their Alta statement too to get the file number off there, correct?
Yes, absolutely. Anything they have from a title company, period. I mean, that can be used as an identifier, for the company that you're going through. They can definitely figure that out.
And what do we do when we have issues on there? Let's say we get the title commitment in, and in this case, you had the heirs, and poor duck died. So, do we call you for guidance as to what types things? Do you guys send that out? How does that work to cover problems or things that come up on the title? Do you see where I'm going?
Right. Well, we always, the first place you want to check to identify any problems whatsoever is your requirement page. That's what's going to itemize any issues that we need to clear up to get to closing. So yes, I mean, if you see something that you're reading and it doesn't make 100% sense, you're just like, well, I think I understand what they're asking for, but I don't know how to get it. Call the title company. I mean, we've created this report, we're issuing it. You have every right to give us a call and say, listen, on item 15, you said you need a personal information affidavit. I don't know where to get that, and we can just say, well, we'll email it to you. No problem. The customer can fill it out before we're at closing. In terms of heirs, we're going to have something a little bit more elaborate. I mean, this Daisy Duck and Donald Duck example I gave was very clean because she's a surviving joint tenant. If you have something more complicated, we're going to have a lot longer requirements page itemizing what needs to be done to get to closing. Maybe we need a death certificate. Maybe we need an affidavit of heirship. Maybe we need proof funeral bills are paid. I mean, there could be a laundry list of things that we need to be provided in order to, close this successfully. So yes, I mean, if it's not made clear on the requirements page, and even if it is, and you just have additional questions or want a step-by-step procedure, call the title company. I mean, our setup, and every title company is different. Our setup is, our downtown office at 205 North 2nd is the title plant. So anything that has to do with the commitment, I mean, we can easily answer any and all questions that you have about it. The 2 escrow offices, they're responsible for preparing and getting it to closing, but they can also, answer any questions about what do we do, where do we go from here? I mean, you always call the title company if you're not 100% sure.
Right. And I was talking to them in the class prior to this about mortgage releases, and to watch for how old they are, or asking if it's their seller, or whether it's their seller or buyer, to make sure, because as you may know, you and Abstracts and I currently have one that we've been working on for 3 months, because the release turned out to be a German company, and it's been a nightmare. I mean, it's been terrible, but we would never have known that had the listing agent didn't know to check that. So I just, those kinds of things, or the affidavit of identity and things like that for common name. I was telling them about that too. So just those are 2 things that they always want to check with you on, right?
Yes. Yeah. If this property is owned by Daisy Duck. So say if there's a mortgage on here that, says it's with, John Doe, let's say, and you have a release of mortgage that we're asking for a release on, and you're like, well, I don't know who John Doe is. I've never heard of him. The most common possibility is that he's a prior owner, and there's an old mortgage that just hasn't been released. So, the possible solutions to that are getting, if we don't have an owner's policy, is getting a prior policy, because somebody had to insure over this. Maybe a previous title company paid this, but a release was just never recorded, which is a very common, circumstance. So if a prior title company issued a policy on this, we can accept that and remove that mortgage based on that, but it has to be the owner's policy. It has to be the policy that they issued to at the time, that was their new buyer, showing that they issued title free and clear. We can accept that to remove that prior lien. And maybe it's a local bank. Maybe it's just a matter of sending an email, to bank XYZ and saying, hey, we think this title company paid this mortgage off in 1998. Can you prepare a release? And, it's resolved in a couple of emails. But some of them, if they're larger nationwide banks, I mean, this is a problem, that you have to kind of do the legwork to get the resolution. So yeah, I mean, definitely, we help as much as we can, but sometimes we need your help to ask the right questions.
Right. And I think we see that too, really common in divorce situations too, correct?
What about old mortgages or?
Old mortgages, or the one party refinanced and the attorney didn't file the release and things like that.
Oh yeah. You always have issues, where the proper things weren't filed, and sometimes it's just a matter of straightening it out.
Right, but it certainly can postpone or kill your transactions.
Absolutely, yes. So the minute you receive that commitment, I mean, this requirement page is gold. I mean, it needs to be at least glanced at, even if you don't read it word for word, to kind of see, what you need. Maybe it's owned in a trust, and maybe the only thing we need is, a trust certification or a trust document. But maybe this person hasn't even thought about this trust since they originated it 20 years ago and have no idea. There needs to be some investigation. This isn't something that you can just leave till the last minute. I mean, most people, know if they created a trust in the year 2000, they know what it's about. They know they're the trustee, they know what attorney they went to. But there's a lot of people that, took one day and went to an attorney, created this, and never thought about it again. So you just got to make sure that your people know, if we need this information, that they either are aware of it, have easy access to it, that this isn't something, because not knowing the details of their own trust, I mean, as simple as that sounds, it will delay your closing if we can't get the proper information in time. So you just have to read it and communicate with your customers to make sure, everybody's ready, everybody's on the same page.
Cool. Thank you.
Okay. All right. If there's nothing else, I'm going to move to the ALTA statement. All right. Okay. So once we've issued the commitment, we're ready to move on to closing. And the closing offices will prepare what's called the ALTA settlement statement. It's a very simplified form. It's just a debit and credit sheet. It just goes over all debits, all credits, and shows both buyer and seller their bottom lines. We split up buyer and seller statement. So I'm going to go over the buyer statement first here. Again, this top box here shows all your specific information. It shows where you're closing at, the address of the property, the borrower, the seller, the lender, and the date of closing. Your first item, or your first debit here, is the sales price of the property, which is $250,000. Your borrower has an earnest money deposit that they've made for $1,000, which is credited to them. They have a loan amount of $200,000 listed next, and a seller closing cost credit of $2,000 immediately after that. So if we go down a little bit further, you have the proration of the county taxes. So as I was discussing earlier on the title commitment, we have 2019 to pay because that is the seller's lien. But also taking that into consideration, the seller has owned the property 100% of the time in 2020. Therefore, they need to give a proration or a flat credit to the buyer so that the buyer can pay this 2020 bill when it becomes due later this year. So we've done a credit for January 1st, 2020 to December 31st, 2020 from the seller to the buyer for $3,970. Now, in that same thought, you have 2020 credited, but you also need to take into consideration 2021. So you have January 1st, 2021 to January 21st, 2021, which is our closing date, and that amount is $217.53. So the seller is basically making a payment to the buyer at the closing to show that they've paid their full responsibility of real estate taxes. So the seller can just walk away from this property and be done with taxes. The only way there'd be an issue, and it's something that's in your contract, is if there's a discrepancy that exceeds $500. So say this tax bill just changes drastically, then the two parties have to resolve any issue with the taxes. Loan charges to the bank. I just listed some random fees. These are not representative of any bank. Some have more, some have less. It just depends on who you're dealing with. But I did an application fee, which is a debit of $375, origination, which is a debit of $600, the appraisal fee, a debit of $450, the credit report, a debit of $45, and flood certification, a debit of $8. Scrolling down to the second page, you have the tax transcripts as a debit of $15, prepaid interest, a debit of $121. The impound section is the borrower's new escrow account. So they're starting off 3 months at $95 per month for their homeowner's insurance, which is $285. And then the property taxes, they're collecting 4 months at $330.83 per month, which is $1,323.32. So that is the total to start the borrower's escrow account, and is completely controlled by the lender. Sometimes they can only collect so much into this account at the initiation, so they usually give a credit back called an aggregate adjustment. And on this particular example, I just did 109 as the credit back. The title charges are listed next. This is representative of a transaction that is a sales price of $250. So these fees are exact for any transaction you have with abstracts and titles. It's $250,000. You have a closing fee of $200, a state mandated closing protection letter for $50. You have the email loan document fee for $25, the later date fee for $50, the lender's title insurance for $250. That particular charge is exactly what we went over on the commitment, the lender's policy to show that they're in a first position with their mortgage. The P-tax preparation, which is $25, state of Illinois policy tax for $3. They have a recording fee to record their new deed and mortgage with the county, and that's usually $60 a piece in Madison County. So for this file, those two documents would be $120. They have a homeowner's insurance premium for $2,200 to pay at closing, and the HOA dues from January 1st of 2021 to December 31st, 2021 is $94.52. So I will tell you ahead of time, I made this example $100 a year. So basically, $100 a year is representative of January 1st to December 31st. And because the seller has only owned it for 21 days in the year 2021, they're only going to pay a portion of that, and the buyer is responsible for the remainder, which is why they have a majority of the payment here. And usually, if they run from January to December, they're due within the first 30 to 60 days of the new year. So we would write that check and mail that off to the HOA company. So then after we take your debits from your credits here on this statement, we show that the amount due from the borrower is $48,943.31. So does anybody have any questions about this particular statement before I move on to the seller statement? Is there anything you want me to elaborate on or go over again? Okay. All right, I'll move on to the seller statement. If you think of anything, just let me know. And then this third page here is just for signatures. It has the borrower's signature and then the escrow officer's signature. Okay, so this is the seller statement. It is a duplicate of the buyer statement, and the only difference is that it just has the seller's fees inputted. So you have the property address, borrower, seller, lender, settlement date. And whereas on the buyer's statement, the sales price was a debit, on this statement for the seller, it is a credit. It's money they're receiving for the sale. Their first debit is the credit that they're giving to the borrower for closing costs, which is $2,000. Now on the buyer's statement, where the tax proration was listed as a credit, money that they're receiving to pay that bill, in the reverse here, it is a debit for the seller, because that's money that they're paying to prepay their taxes so that they can have their taxes paid in full when they sell this property. So it's the same as the buyer's side, $3,970 for 2020 and $217.53 for 2021. The seller's closing fees for a $250,000 transaction, you have the closing fee for $200, closing protection letter for $50, later date fee for $50, state of Illinois for $3, the attorney fee for the preparation of the warranty deed to transfer property from the seller to the buyer is $50, and the owner's title insurance is $665. So in Illinois, it's different in other states, but in Illinois, the seller pays customarily for the owner's title insurance policy, and the buyer pays for their lender's coverage. So that's why the charge is listed as a seller charge. It is the buyer's insurance, but the seller buys it on their behalf customarily. So the top of page 2, we have the commissions. So you have the first commission for the listing agent, $6,250. The second commission for the selling agent, $6,250. You have the county and the state charge transfer stamps to sell the property. It's basically a tax. So the county receives $125 and the state receives $250. The payoff that we had on the requirements page of the commitment to Mulan Bank, it's shown as a payoff here for Daisy Duck as $100,000. And I purposely left the 2019 bill unpaid, and it was originally, let me go back to the taxes here. The bill without penalties was $3,970, but obviously this bill is late at this point, so she's paying penalties in addition to that, which is $4,040 for the 2019 taxes. 2021 HOA dues, she's paying from January 1st to the date of closing, which was January 21st. So if they're $100 a year, the seller's portion is $5.48. Home warranty that's being provided to the new buyer is $500, and there's an invoice for miscellaneous repairs, which is $900. So after the debits and credits are taken into consideration, the amount due to the seller is $124,473.99. And again, down at the bottom, seller signs along with the closing agent. So that in a nutshell, in the first time you look at it, it may look a little Greek, may look a little odd, but it's a debit and credit sheet. So the more you look at it, the more it becomes very easy to read. You'll know exactly where the commissions are at. If you have any miscellaneous fees, those are always in the miscellaneous section. Any invoices, anything like that to pay, those are listed, in that area there. So it just becomes, really easy once you see a couple of these after your first few transactions. And if anybody has any other questions, I will say, this is just a general overview. So if anybody has their first file, with abstracts and receives their first commitment, I'd be more than happy to go over this, over the phone, or if you want to email me, just call. I'm at our downtown Edwardsville office, 618-656-1275. I'm sure Pam knows that number by heart, but just give us a call. I mean, we're very happy to go over this with you. We want this to go, just as smoothly as you guys do. So don't hesitate to, give us a call. We both have the same goal at the end. We both want this to close as, smoothly as possible. So we'll help you do that. And, because we all want to get this finished, but if anybody has any other questions, please let me know, and I'd be happy to answer them now, but I'm always available to answer any questions if needed.
Okay, well, looks like we got no questions. Anybody going once, going twice?
It's not an interesting subject. I
mean, we probably get more questions from agents asking, what do I do to a settlement sheet? What am I supposed to look for? And as well as I know, as well as Pam knows, the first thing that an agent looks for on a settlement sheet is what's the commission.
Right.
That's the first thing we all look for. Is my commission on there?
Right.
And how much is it? That should actually be, and I'll give you guys a piece of advice. That's the last thing you should be looking at.
Very last thing.
Well,
because there are so many other things that you have to look at on that settlement sheet.
Yeah. And sometimes you don't even know what questions you have until you really get into your first file. I mean, you may have a situation you've dealt with numerous times before, on your third file, but then by the time you get to your sixth and seventh file, you're going to have something that you've never seen, heard of before, and that's the time when you're just loaded with questions. So, that's why I can't.
600 file, you end up with questions, I mean, I still called you and went, what the heck is this? Like, I have no idea.
It happens. So, that's why, I can't stress enough. We're always here. There's plenty of us, on staff that have been here a while, and, we're more than happy to talk title insurance. You either love title insurance or it bores you to tears. So, you're going to find a lot of people at our office that just, will talk to you until you're full of it.
Yeah.
I do have one question, Lisa. Yeah, and you mentioned this early in your presentation. You were talking about title insurance.
Yeah.
So a great idea when you are dealing with a customer, especially Liz, you're going to be dealing with a lot of military customers, right? You know that.
Yeah.
Have them, when that policy is mailed to them, tell them it's going to be mailed to you. I want you to put that in your important paperwork. Do not throw it away. Do not lose it. Put it in there, because 2 years from now, 3 years from now, 4 years from now, when you go to sell this house again, I want you to be able to pull that out and send it to the title company, because you're going to expedite, number one, and you're actually going to make life easier on yourself, and it might even be a little cheaper.
Yes. No, it's always important. And that, it's just like any other policy. You have to know what to file a claim under. So, if you have an issue, you have to know what your owner's policy number is, who you need to contact. There's plenty of underwriters in the country, so you need to know. Ours is Fidelity. So your customer needs to know, what underwriter do I need to contact, if there's an issue. So, it's just like any other policy. It's highly important, and, you just need to keep track of it in case you have any issues. That is your proof that you own the property free and clear. It's important.
I have a couple of mentions too. You guys, if you have a divorce situation, okay, be sure that you can provide or know where they're at in a divorce situation as you're representing the seller, okay? Or even when you are the buyer's agent and you know the listing agent, or it's a divorce, okay? Be clear on getting the documentation to the title company, or even assisting the listing agent in doing that. Always ask the question, hey, I noticed that they're getting divorced. I'm sorry to hear that. Just want to make sure that we've got, because even right now, Lisa would, I think, agree that it's really hard for them to get documentation from the county. The county's only letting them in for a couple of hours a week. So It's super, super hard for them to get information. So the more information you can give the title company up front, the smoother things will go. The other thing is, if you have someone who's, and I know we're going to be doing a lot of investor properties, where the person is actually a part of an LLC or an S corp or a C corp. If they're signing as, part of a corporation, or, Joe's investment company, you're going to want to get their articles of incorporation and make sure that they are the authorized signer, because title company is going to ask you for those eventually. So you might as well just get them up front, okay? And then shoot them over to the title company, then all things go away after that, unless there's a problem. The other thing is, inside of that conversation, if they are not the authorized signer for that corporation, you do not have a contract unless that person's buying it themselves, okay?
Yeah.
And lastly, I would say I think, and I don't know if you'll agree with me, this, I hope so, is, the more information and more assistance you can give the title company up front, the better things go in the end. Like, Lisa's right, you either love it or you hate it. I particularly love title insurance, love it. So just bear in mind that anytime you're ordering title and you think there might be any kind of abnormality or issue, call the title company up front. These ladies, particularly from ABS, will help you all the live long day. All the title companies will. ABS is just my favorite. And they, they'll just get you educated and informed, so much so that you'll be able to have a conversation on the next transaction that you have with your sellers and buyers and explain everything to them. So
yeah, and I think, just to elaborate on that, you have to look at it from our perspective. Our job is to verify we have the correct seller in the room, the correct buyer in the room, and we're doing everything that's required from the lender. So when she's talking about the papers for the corporation, for the LLC, for whatever the case may be, our end goal is to prove who we're having signed is the authorized party to sign. So, anything you have that isn't just a straight individual or a husband and wife or, whatever the case may be, you have to have that proof that the entity is being represented by the same person, or the right person, I should say. So, I mean, just always keep that in mind. We're all about proof. We have to have proof. We have to have, all the documentation in order to make sure we're issuing the policy correctly. So that's the important thing. You just have to make sure that the customer is aware that if they're not just John Doe, that we have to have proof that this company is represented by John Doe for him to be able to sign any documents to properly sell the property.
Yeah. I had a question day before yesterday. Now they're advertising on TV about how people are, quote, stealing your title. Have you had any questions about that? I mean, has anybody seen those commercials where they're like, holy moly, really? I didn't even know that.
I'm aware of the one where they like solicit payment for copies of the deeds after closing, but I've never.
He comes on TV and he goes, the new scam nowadays, they don't go after your credit cards now. If you're not keeping an eye on your title and your deed, they can steal your house and you'll never know it. And I'm like, holy cannoli. And I meant to call you and ask you, and I completely forgot about it until I saw you this morning.
No, I've never heard about that. But I mean, if any client ever has any concerns about that, I mean, we can't do a full search immediately, but I mean, the recorder's office, you could certainly call the recorder's office and see if something's been recorded without your knowledge. Obviously there's an issue of fraud involved, but
that's what they're saying. That's how they're the new line of thieves stealing your property. And I'm like, how can they do that?
I'll have to look into that, because the only way that could be done with real estate is if you file a fraudulent deed.
Right.
I mean,
what it is, it's a scare tactic for elderly.
Yeah, that's usually what.
That's exactly what it is. It is a scare tactic for folks, because Pam watches old people TV, and they actually target those commercials to people that the demographic that watches the TV during that time of day and watches that particular. And obviously Pam watches old people TV, which is Newsmax, and so that's why that scare tactic.
Yeah, that's. Well, I figured it this way, bear to question either way, whether it's old or not. I don't care if you. And I want to be able to say something to my clients who ask me. I want to be able to speak intelligently on it. And currently, I'm not so much in that area.
Yeah. So. Well, I will say that the thing that they've done for years now is that they'll send, there's companies that keep track of properties that sell, whether through the newspaper or whether they have access to the public records. They keep track of properties that are bought and sold, and they send out mailers to the new buyers, and they have this, huge notice that says, you don't have a copy of your deed, you need one immediately, and then they'll say, give us $90 and we'll send you a copy of your deed. Well, first of all, this is a document that the title company is going to mail you in 60 days free. And if you ever needed a duplicate, I don't know other counties' charges, but I mean, I think Madison County is like $1 or $2 a page. Right. So, I mean, you're talking about something that they're trying to frighten you into thinking you don't have the correct copy, and they're collecting, an $88 profit here to just give you a copy of a deed that's public record. I mean, even if you don't have a copy of it, it's irrelevant. It's public record. As long as that's documented, that's all that counts.
And I know that's here. I've actually had 2 instances of that in the last 2 weeks. One of the agents called and said, "Is this a scam?" Yes, it's a scam. Yeah. 2, a client that I sold a house to called because they got that exact letter. Yeah, and they were in a panic of, "Oh Lord, what am I supposed to do? Yeah. Help me." And my response was, tear it in half, throw it in the garbage. You're going to get it. You're going to get it in 60 days.
Yeah.
But they were in a panic of, well, I don't have this. And they tell me the way the letter read, it said, you have to have this. You need a copy. and you need it for your important paperwork for, God forbid something should happen. And my buyer was just in an absolute tizzy,
Mhm.
and I calmed down.
Yeah.
No problem. Let's be the calming factor here. But it is here. It does happen, and I think it happens on every transaction.
Yes. Yeah.
I actually got one when I first bought my house. I called Alicia and I'm like, oh my God. And she's like, no, it's fine. I'm like, okay.
It's a shame. It's a shame that they make that much money for something that's absolutely public. So, but yeah, we get somebody once a week that's calling or coming in and, saying, I got this letter. What do I do? And it's just unfortunate. So, but yeah, it's always something to keep in mind to tell new buyers that they're going to receive this and just, throw it in the trash, disregard it. It's not important. So,
yeah. Cool. Well, at least it's, knowledge is always power. So now we know, everyone now knows I watch Old People TV. Thank you, Barry.
Old People TV.
Old People TV. And thank you, Barry, for that. So, but also now I know that they've just taken that letter and gone viral, if you will, with it and made it. They actually want you to send them money for a service. And I'm like, what? No way. I got to ask somebody about that crazy crap. So good to know.
Yep. Well, like I said, if you guys have any questions, any issues that come up, I mean, please, don't hesitate to contact me. Pam has all my contact info, and
I even got a cell phone, y'all. No.
They hang out and watch Old People TV together.
Yeah. I'm excited now.
We'll do that with margaritas, right, Lisa?
Right. You have to, otherwise it's not enjoyable.
News is a whole lot better with margaritas.
Right. That's exactly right.
It's necessary at this point, so.
Amen to that. So. Oh my goodness, Lisa, thank you so much. I always love listening to you, and as always, I love that laugh that you have. That's my fave.
Thank you. I get that a lot. I'm glad because it drives me insane, but I'm glad everybody else enjoys it.
Yeah, Lisa, thank you very much for spending time with us today. I hope everybody got something out of it. Those that are watching this after the fact, I hope you do get something out of it, and keep Lisa and Abstracts and Titles in mind next time you decide to choose a title company.
Yeah, we appreciate it.
Thanks so much.
All right, I'm going to leave you guys to it. Have a good day.
Thanks.
You too.
Bye.